Ranchez versus City and County of Honolulu is an example of the application of just the black letter doctrine of the rule that prohibits subsequent remedial repairs from being introduced into evidence. Now, as we've learned in the videos we've had on subsequent remedial repairs, the idea is that we don't want to discourage a company, a city, a state, any kind of entity or an individual from doing things that would prevent the harm that has occurred in this litigation from happening again. We want people to repair the sidewalk in front of their house or in front of their ice cream parlor. But that doctrine is at odds with our getting the right answer in this particular litigation. If we're trying to figure out if, in fact, the sidewalk in front of the ice cream parlor was the reason for the slip and fall, it is certainly relevant. It is certainly something that makes it more or less likely that the sidewalk was at fault. If we know that after the accident, the owners of the ice cream parlor came out and repaired the sidewalk, it doesn't prove that it was the fault of the sidewalk and not the person walking on the sidewalk. It doesn't prove that it's the fault of the sidewalk and not a biker who scared the person walking on the sidewalk, but it is some evidence. But in excluding that evidence, we're denying the trier of fact something important, something that's relevant for helping us make this decision. So courts are very guarded about rules that limit the admission of relevant evidence. So in the case of Ranchez versus City and County of Honolulu, we have a case in which the victim, the plaintiff, slips and falls in a Honolulu bathroom. These are the bathrooms. If you've been to Hawaii, the state of Hawaii has several public restrooms for folks who go to the public beaches so they can come in and use the restroom. And in the course of using this bathroom, the person slipped and fell. And at the time, Honolulu had already planned to fix up this bathroom. So the question is, does the doctrine of subsequent remedial repair apply when there's already a plan in place to repair the bathroom? And the answer is no, because the court reasons in the Ranchez case that if there's already a plan in place to fix this bathroom, then even if we admit that evidence, the city is not going to say, look, call this thing off. Call off all subsequent repairs because we're worried about the admission in this case. This thing has already been planned. They probably won't stop the works so that they'll not have it used against them in this particular trial. So understand the purpose for the rule and ask yourself the separate question of whether the admission of this evidence will, in this particular case, are there reasons in this particular case that make you think that the concern that we have won't come to fruition? That is there something about the uniqueness of this particular case that suggests that there will be no deterrent of subsequent remedial repairs, even if they are admitted in court? And this will certainly be true in the International Harvester case that we look at next. Are there unique concerns about the way the case goes down that makes us think that the repair that was made that will help us figure out liability or fault? Are there certain facts about the particular case that suggest we don't have to worry about the general policy that tells us we don't admit that for fear that will discourage repairs? Look at the facts of the particular cases as you see in Ranchez and as you'll see in the International Harvester case. There are times when our fear that companies will be afraid of the admission of this evidence and therefore not make the repairs, there are times when that simply won't be a concern. And those are things you need to look at as you examine whether Rule 407 actually applies to a case.